Is the law equal for everyone? For nearly half a decade, Cullman County has been in a legal battle over its bail system and its impact on the county's most vulnerable people.
Tonight, we go in depth on the push to take this case to the U.S. Supreme Court and talk to some of the state's top defense attorneys about the challenges still faced by some of Alabama's poorest defendants. For those who find themselves inside a courtroom, bail is often the first hurdle. Criminal defense attorney Richard Jaffe.
One of the worst fears that people have is losing their freedom. And it's also the most cherished right we have other than the right to live.
And for those who are indigent, the odds can seem stacked against them. Even a low-level criminal charge and a low bail can still mean sitting in jail until trial. Tommy Spina has been a defense attorney in the region for more than 40 years.
I think cases need to be judged on an individual case-by-case basis, and that there shouldn't be a one-size-fits-all predetermined consequence about anything.
It's exactly what a federal judge in 2017 ruled was not happening in Cullman County. A civil suit argued fixed bail amounts made it impossible for the indigent to get out of jail.
When someone is unable to get out on bail and work and support their family and be with their family, I'm not sure anybody benefits.
The Cullman County Sheriff's Office didn't see it that way. It argued defendants began not showing up to court, and local law enforcement found themselves arresting repeat offenders in greater numbers while an injunction on the policy was in place. But in 2022, the 11th Circuit Court overturned the ruling in favor of the county and its bail system. But the fight may not be over. Now the American Bar Association and other influential groups are asking the U.S. Supreme Court review the case and the ruling.
My personal view is that the cash bond system in our state needs reform. But what's really happening is the legislators in our state are trying to make it harder.
In 2016, the Prison Policy Initiative, a nonprofit which advocates against mass incarceration, said 70% of people in local jails across the country were being detained before convicted of a crime.
Getting out on bail is the cornerstone of the presumption of innocence. It's the foundation of our democracy and our freedoms.
Other counties in the state have shifted away from the cash system. Spina points to Tuscaloosa, which he says allows defendants to post a portion of the bond, which is returned once they show up. They are not alone.
In Jefferson County, they will let you sign yourself out on a bond up to $15,000. That's a big number. And that really cuts into the bail bond business.
But it is the other side of this coin. In Cullman County, one bonding company during the injunction told ABC 3340 it normally issued over 100 bonds a month, but then only issued 14. So what happens next? Does keeping the current system ensure criminals stay off the streets, as law enforcement argue, or does it trample the rights of Alabama's poorest defendants? The answer may now lie in the hands of the U.S. Supreme Court.
There are some very interesting legal and constitutional issues. So I think there's certainly some chance that the United States Supreme Court will decide to take a look at this.
The U.S. Supreme Court has not decided as of right now on whether or not it will take up the case. The Southern Poverty Law Center says nearly 80 Alabama cities have reformed their bail practices over the course of the last half decade. Now, to be clear, these practices we discussed do not affect violent crimes, which now require no bond in virtually all cases, thanks to the bill recently known as Aniah's Law, which was passed into law.